This second session on the topic of settlement of disputes between states introduces the differences between the so-called diplomatic or political means of settling disputes and legal settlement of dispute mechanisms in international law. The mechanisms that states can resort to in order to resolve their disputes are commonly categorized into two groups: diplomatic, political means on the one hand, and legal adjudicatory means on the other. Let's see the main features that characterize each category. The main feature that distinguishes the so-called legal and political mechanisms of settling disputes is their outcome. The final agreement or decision or compromise reached by a political means of settling disputes is non-binding in principle. However, we will see that during the process of resolving a conflict using a political mechanism, the parties may decide to sign a binding agreement, typically a treaty. So, the outcome of a political means of resolving dispute might be reaching an agreement that can become binding if the parties want to, but the means of settling the dispute themselves does not have as natural outcome a binding result. Other characteristics that are special or characterize diplomatic means are their flexibility, since the parties are free to decide whether they want the intervention of a third party or not. If they decide they want a third party, they are also free in choosing who that third party will be and to provide instructions on how they want the third party to proceed and on which basis. The proceedings will also be confidential in principle unless the parties decide otherwise. We will see a case of conciliation between Timor-Leste and Australia, for instance, where the parties decided to make public the final outcome. But in principle, these proceedings are confidential. As we will see again with other specific examples, the freedom of the parties to choose how to resolve their dispute using political mechanisms also means that their equality is not guaranteed, nor the impartiality of a third party if a third party is involved. The political settlement of dispute tends to seek a solution that will be a compromise between the parties regarding their positions. The aim tends to be to approach opposite claims or positions rather than determining which party is right or wrong. International law might be relevant and might be applied in resolving the dispute or might not, depending on the will of the parties. Conversely, when the parties of an international dispute seek the intervention of a legal mechanism, they are seeking a binding solution. Mainly for judicial adjudication, not so much for arbitration, the process and the final outcome will normally be public. In general, publicity and transparency is greater for legal proceedings. Legal means of settling dispute work within a framework of rules governing the behavior of parties and judges or arbitrators. Therefore, whatever form of adjudication states decide, the organ called to decide will establish rules of procedures to guarantee due process, the impartiality of the adjudicatory body, as well as the equality of the parties. While a state party to a dispute can decide that the adjudicatory body makes a final decision based on equity rather than international law, this is an exception. And in general, the final outcome will be decided on the basis of international law, and the full procedure will be regulated by international law. That is, on the basis of interpretation of treaties, customary law, general principles of law, or unilateral acts of states. Precisely because law will have a prominent role, these proceedings are adversarial in nature and tend to involve a confrontational approach and also an adversarial process where a final decision adjudicates who wins and who loses. This has the potential to crystallize rather than resolve an international dispute. Before I conclude this video, let me clarify a preliminary issue. A consequence a result of the freedom of choice enjoyed by states to resolve their dispute is that many mechanisms can be attempted to resolve a single dispute, as we will see through different examples. While there is no hierarchy or obligation to attempt one mechanism before another under general international law, normally states will start with negotiation. Also, it may happen that the Security Council of the United Nations decides to intervene motu proprio. As I said, we will use as examples conflicts where multiple mechanisms, political and legal, have been used to resolve a dispute. Overall, general international law operates under the premise that in order to achieve a peaceful settlement of dispute, it is better to leave all the doors open through multi-pronged strategies. So, as I said, it will be normal that the states start with negotiations and then they can move to mediation, good offices, and then end up in a court and even interrupt court proceedings with more negotiations. We will see several examples of this.